Very good morning to all my dear students and listeners. Today we are going to discuss about notice drafting of notice for specific performance of contract under the subject captioned as drafting, pleading and convincing. My dear students and listeners, before starting with the today's lecture, I just want to apprise you with the concept behind specific performance as contemplated under the Specific Relief Act 1963 and its relationship with Indian Contract Act 1872. So my dear student, let's start with the same. As you all are aware that a contract is a written or an oral agreement which is legally enforceable, entered into for a particular purpose by two or more parties, where each party assumes a legal obligation that must be fulfilled. Further, Section 10 of the Indian Contract Act states that an agreement becomes a contract if it is entered into with the free consent of the parties for a lawful consideration or for a lawful object and it is not void. Further, the elements of the valid contract are offer. The very first element of a contract is an offer. Without an offer, there can be no contract. It is important for the party to make an offer to another party so that it would be legally capable to enter into a contract. When an offer is made, the party would know what is being offered and what the other party wants in return. And second concept is, or second element of valid contract is acceptance. After an offer is made, there must be an acceptance of that offer from the other party. The acceptance would mean that the other party is well versed with the rules and regulations of the offer. Acceptance can be made either orally or written. Third, consideration. This is also a very important element in a contract, which means that the other party would want something in exchange for doing something or abstaining from doing something at the promiser's desire. Fourth element is legal object. The fourth element of the contract is its objective. The purpose for which a contract is entered into must be legal, otherwise the contract would be void. Fifth element is capacity to contract. This is one of the most important essential element of the contract. The parties must be legally capable of entering into a contract. According to Section 11 of Indian Contract Act, parties must be of sound mind, have attained the age of majority, have not been disqualified from entering into a contract by any law to enter into a contract. And last one is mutuality of obligations. So in this reference of contract law, I would like to explain what is the meaning of specific performance of contract. Meaning thereby, parties to contract must perform their contractual obligations. Otherwise, they can be sued for non-performance. And this remedy of specific performance is a discretionary remedy made by a court, wherein a party to the contract must perform a specific action as outlined in an existing contract. Specific performance can refer to any kind of forced action, though it is usually enforced so as to complete a transaction that had been previously agreed to. One of the reasons, my dear students, wherein the court orders specific performance is because in some contracts damages cannot be remedied by way of money, meaning thereby monetary compensation is not an adequate relief, and in those cases the court may grant specific performance. With regard to specific performance, I would like to submit that legal action brought into a court compelling a party to carry out the terms of the contract, meaning thereby in this remedy of specific performance, a legal action can be brought in a court of law, thereby to compel a party to perform his part of contract. Further, the court's jurisdiction can only be attracted if it is in breach in a real estate contract is such that it cannot be compensated by money. Contract cannot be specifically enforced for personal services, nor can it be enforced on an illegal contract, an ambiguous contract, or a contract where there is an inadequate consideration. So my dear students, while drafting a notice for specific performance of the contract, these essential points need to be considered. Further, the amendment that took place in 2018 in the Specific Relief Act must also be taken care by a law student or by a lawyer while drafting a notice under section or notice for specific performance of contract. So let's start with the drafting, wherein I will provide you the format for drafting this notice. As you all are aware that there must be some title to the notice. As such, the title to the notice for specific performance would be as Notice for Specific Performance of Contract. There must be a date. This date is the date on which this legal notice is being sent to the other side. Further, it must also mention the fact whether the notice is being sent through the registered AD or by UPC or by any other specific mode of service to the other side. Further, it also bears the name and his designation of the other party. Further, in this subject, it may be mentioned that this notice is with regard to sale of the house number so and so, situated at so and is owned by so and so. That is the addressee. Thereafter, you may write, if you writing in the capacity of a lawyer, then you start the drafting as under the instructions from my client, Siri so and so, son of Siri so and so, residing at so and so. I have to state as under. My client had entered into an agreement for sale. As you all are aware that the sale of an immovable property generally divided into two parts. Firstly, the parties entered into an agreement to sell and thereafter entered into a valid sale deed. And at the time of the sale deed, the possession is also being handed over to the other side. But if the possession and the whole money amount has not been paid, meaning thereby the property is to be transferred at some future time with regard to an agreement to sell. So we have to write it as my client had entered into an agreement for sale dated so and so with you for sale of house number so and so situated at so and so for a consideration. As you all are aware that consideration is one of the essential element of a contract as provided under section 10 of the Indian Contract Act, further explained under section 23 of Indian Contract Act, and its exception are given under section 25 of the Indian Contract Act. So my dear students, we have to take into consideration not only the provisions of section 10 but also of 23 and 25 as well. So we may say that there is an interplay or an interconnection between section 10, section 23 and section 25 of Indian Contract Act with regard to this. And in terms of the clause number so and so of the said agreement, that is agreement to sell, the said transaction is to be completed within a period of 2 months, 3 months, you may put it like that, because generally as per the provisions of section 55 of Indian Contract Act, wherein the time is an essence of the contract for an immovable property. So you have to mention that there is a time limit for the performance of the contract with regard to sale of immovable property. And if the party fails to fulfill his obligation within the contemplated period or within the stipulated period as provided under the said agreement, then the other party has the remedy to approach the court for the specific performance of the contract. Next. My client was and is still willing and ready to execute a sale deed in your favor or in favor of any person as you may direct in accordance with the terms of said agreement, but the same was not done for reasons of your own. So my dear student, as you all are aware that the party or the victim party or the aggrieved party must have to show before the court of law that he is ready and willing to perform his part of contract, and it is the other party to the contract or an agreement who is not willing to perform his part of contract. As such, you pray before the honorable court for specific performance of the contract on behalf of the aggrieved party. Further, you may write thereafter that I hereby call upon you to have this deed of conveyance or sale deed executed by my client against payment of the balance consideration amount on or before the dash date in terms of the said agreement, failing which the said agreement will stand cancelled and the earnest money paid by you will stand also forfeited. And next, however, this notice is without prejudice to the rights of my client to recover all costs and damages, losses, and expenses incurred by him by reason of your default in performing the said agreement. So my dear student, this is all about today's lecture. Hope you have enjoyed it and also learned from it. In case of any query, then you may write it to me at my email ID, which I had already given in my previous lectures. But before parting with today's topic, I just want to apprise you about my new topic, which I am going to take in my next lecture. And my next lecture would be on reference to arbitration and deed of arbitration. Thank you very much. We'll meet you soon in my next lecture. Till then, stay home, stay safe, and stay healthy.